trial, but guess what? The McStay trial's attorneys, the judge, the prosecutor, are still at the bench discussing this issue about, and I think it's getting to this issue about, is there what's called a SODDI defense? Ronn Blitzer is my guest. I'd like to bring him in. He is the senior legal editor of Law&Crime here. It stands for, in legal terminology, Ron, some other dude did it, okay? And I think they're trying to get to the import that maybe a man named Dan Kavanaugh was a suspect, or should have been a suspect that should have been investigated more. If there is evidence that some other dude did it, the SODDI defense, do you think the judge should be pretty lenient letting that in?
Oh, absolutely. I think that, I mean, there's certain restrictions, on certain types of evidence, but, a lot of the objections that we've been hearing here have been regarding hearsay. When you hear the attorney saying, oh, well, did Kavanaugh tell you this? Did Kavanaugh tell you that? And you have objections.
Right.
But if there is a statement against someone's interest,
right,
that is an exception to the hearsay rules. So
right,
you can, if you have someone saying, oh, Kavanaugh said that he was going to do something bad, or he was going to do something that could be brought in as evidence that he did do this, then that could be heard by the court.
And this is who should be the judge here, Ronn Blitzer, because you're absolutely right. It's called Evidence Rule 804. And attorneys always have to object in federal court. Let's say it's an evidence federal court rule. By the evidence rule, if you're a good attorney, or else the judge will go to you. And that's it. It says if it is against your interests, like you threatened to kill somebody, or you said, I killed this person, it could be years later, that's a statement against interest. Even though it's hearsay, it's considered reliable. Now, why is reliability important in the courtroom for this?
Because, when you're hearing something, especially something where you don't have that person there to respond to things, it's a question of how reliable is this evidence, because if the jury is hearing this and they don't necessarily buy what they're hearing, and you don't have any other evidence to kind of corroborate that,
not fair,
then it's not as fair. It comes off as weaker. There's not really a whole lot you can do about it.
Well, let's talk then about DNA. I was interested in the apple, because usually when I was growing up, you saw red apple, there was some like bad queen with Sleeping Beauty and fairy tales, and that was pretty a red apple. The defense attorney got this investigator, remember he was the lead investigator on Where the Family Is, to say that he didn't think, and I'm going to quote, that he didn't see the value of collecting something that could rot. Now, you are a trial. I'm going to just manage you to be a trial watcher. You're not an expert. You're nothing. From what you know about watching CSI in the courtroom, does DNA rot?
Now, you can find DNA evidence later on, but what also blows my mind is that even if you think that something's going to rot, then do something with it at the time, so you can at least get something, even if you can't bring it into a trial months or years or however amount of time later, at least do something. And I think that this is something that the defense is really trying to instill in the jury, an impression that they're trying to give here, that this detective was not exactly thorough in his investigation.
To say the least.
Yeah. And, we're talking about Kavanaugh and the SODDI defense, and, we just heard some discussion about whether or not he, looked into Kavanaugh, and he was saying, at first he didn't question him. Oh, why not? Oh, because he was in Hawaii. All right, sure. Well, did you verify this? Oh, well, he gave me a receipt of a ticket. Oh, well, did you?
Or even better, something printed off the internet.
Exactly. He got something off the internet to show, oh, yeah, I was in Hawaii. This is it. In the time that we're here, I can make something like that.
Wow. So, wow. This is why this is the juror, the judge, everything. But we're going to go back in the courtroom because apparently they're going back to ask questions. Wow. Okay. So, it's my nature. They said, any more recross? I said, yeah, I have recross, Ronn Blitzer, senior legal editor. I have recross. Let's talk about some of it. The detective, this is a family that's missing. This is a tragedy. Let's remember that. 2 little kids, 4 and 3, and their parents dead, missing, and discovered in a desert, it's just a terrible case. So this detective from San Diego said, well, he wouldn't fingerprint the house because he had no evidence of a crime, but he kind of made a joke of it. He said, well, it would take too much time. I'd have to put the whole house in. You see crime being reported on every single day. Do you ever see the house being dipped in fingerprint powder?
No.
And I'm being facetious, but no, right?
No, you don't see that. And
that's because why?
Because it's not relevant. You're not going to, when you're looking at an entire house,
right,
you're going to see fingerprints from everybody who's been in the house.
So you have to pick and choose,
exactly.
right?
You're going to see guests. You're going to see the people who live there. You're going to see anyone who comes and goes, and a lot of it's going to be completely irrelevant.
So if you think somebody either touched, for instance, the apple or the counter or a forced entry, put your fingerprints right down. Put your hand down here, right? Okay, we're going to have somebody clean. I wish I do have my camera. I should take that because you guys can't see that at home. But there is Ronn Blitzer's fingerprints there because he touched a surface that's very good for fingerprints, such as glass, where people break into houses, they open windows. So it's the selection that's important to use the test. And that's where I'm having a little trouble here, Ron. Let's talk about something else. There was, before we went to the last break, the defense attorney on cross-examination wanted to get in something, and we don't know what, about a Mr. Pugsley, who we think is the grandfather of the person they're saying some other dude did it. We're not saying that. They're saying it. They're trying to point the finger at this man called Dan Cavanaugh, who was also a partner of Mr. McStay, or in the business with Mr. McStay, not necessarily a partner, who sold the business afterwards, even though he didn't own it, etc. I don't know what they were getting at, but whatever it is, it sounded pretty important for the defense, right?
Oh, absolutely. If the defense, and we see that they're trying to push Kavanaugh as this third party who could have been responsible for this, they're trying to bring in evidence to support that, to create reasonable doubt, to get a not guilty verdict here, and the judge doesn't even let them bring it to the jury's attention, then if they lose the case, that's going to be brought up on appeal instantly.
Yeah, I was always taught as a prosecutor that when you win the case, you want to make sure it is appeal-proof. It is not able to be rebutted. It does not come back to you later on in a worse situation after it goes to appeal, and I think the defense is creating a record. We have so much to talk about, but you know what we have to do from time to time? We have to take a break from time to time, and I think now would be a good time to take that break. This before we get to the next throw, but you're going to do it while we're listening to him. If you're Detective Dugal, why do you call in dogs that search for dead people and dead bodies and decomposing tissue if you don't think there's been a death? I wonder if we're going to get the answer in the next clip.
Detective Dugal, I was going to get to the cadaver dogs before the break. So on February 19th, when you were executing this search warrant, you said on direct examination that you called in the cadaver dog. Is that correct?
That's correct.
Does that mean that while you were there you called it in, or did you?
Okay, so we're going to go to the next clip to see if we get an answer there, okay? Let's listen. I'm listening. You too. Oh, well, you know what? I think it's taking him some time maybe to give us the answer about this. Right, Ronn Blitzer?
Yeah.
You continue to tell me why you call cadaver dogs if you don't think there's been a homicide?
Yeah, it's a really weird question. And, when you're a defense attorney, you're trying to show that the police slipped up in their investigation in any way, shape, or form. And when you get information like this, when you get answers that just don't make any sense, that's a defense attorney's dream, because then they can look at the jury and say, well, this doesn't make any sense at all. Why are you calling cadaver dogs and then saying, oh, well, it's not a crime scene?
Yeah, I don't know the answer to that. And here's the problem I have, Ron, is that this is a real tragic case. This is a family of four, eventually we know were murdered. And I think there's no issue about it. I'm going to say they were murdered. I just don't say by who. But you want to get the right person. You want to get the person who is guilty, and you want to convict that person. And when you see this, that leaves so much for people like me if I'm in that courtroom. Now, I don't know whether Merritt's guilty or innocent or not. We're going to find out, right, from the jury, hopefully. But if he is guilty, and he gets acquitted because there's mess-ups, that's bad. And if he isn't guilty, he gets acquitted, he gets convicted of mess-ups, that's bad. What's worse, the conviction of one guilty person or letting, not convicting a guilty person?
I've always been of the opinion that convicting an innocent person is far worse than letting a guilty person go. I mean, that's what our system's based on, innocent until proven guilty. If the prosecution, if the government can't prove their case, even if you did it, if they can't prove it beyond a reasonable doubt, you're free to go. That's how things work here.
Yeah, you know what? I had a case in Tennessee. A man was on death row for over 2 decades. His name was House versus Bell was the U.S. Supreme Court case. It came back, and I was assigned to help the local person who was trying it try it. It was the public defender's office, but it's got a different name. name in Tennessee. And the theory there was that he was wrongfully convicted on, but it was a good theory, that the mother who was eventually killed, the woman, was lured out of the house by somebody who was close to her that she trusted. Said, oh, your husband's been in a terrible accident, or your father's been in a terrible accident. You got to come quick. So she went running out of the house without shoes or whatever, and then she's found dead sometime later. Could that have happened here? In other words, could the prosecution theory be, shall we say, not good?
Yeah, it can absolutely be a flawed theory by the prosecution. And when you're getting evidence, information from the detective here, and you're seeing what was done to lead to the prosecution having their theory and having slip-ups and some really shoddy police work, in my opinion, here. It's really bad for the entire case because, as you were saying, even if they get a conviction here, if it's so weak and there are so many technicalities and missteps that the defense
It's called due process.
Exactly.
It's called due process. But I have to now throw to a new clip, and this is a really interesting one because this is one where this detective now says, after the prosecution says he points it out, blood spatter on a table for several, let's see, how many days after? He's called in on the 15th, but they went missing on the 4th. 4/19 from 4. Over 2 weeks later. Let's hear how this happened.
Have you, in your career as a police detective, seen blood spatter?
I have.
So what you see in the bottom part of this photograph, you can't say it's blood, right?
I can't say it's blood. It's a horrible moment where I don't know what it is. I did not see it with my naked eyes when I was in the residence at all. And now that the district attorney zoomed it in, it puts a pit in my stomach, but I don't know what it is. I can't say it's blood, and I can't say it isn't blood.
Does blood dry in a specific pattern?
It does.
How does it dry?
No foundation.
Sustaining foundation.
You received training as to how blood spatter or blood will dry.
I went to a 40-hour course by the San Bernardino Sheriff's Department for blood pattern analysis.
Does blood dry in a specific manner?
Yes. How? It traditionally, obviously, dries at where it's thinnest on an object. If it's blood that's spattered onto an object, the outside or the thinnest edges are going to dry first, and then the thicker or the raised area is going to dry later. And in this, what you see is skeletonized. We call it skeletonized drop of something.
Well, more than one drop.
A lot of drops.
Well, let me just educate a little bit, because whenever we try cases, we try to educate. There's something called the National Academy of Sciences, Ron, and it issued a report, like 10 years ago, and it said that sciences have to have foundation, they have to have scientific foundation. Now, this detective took a course many years ago. He doesn't even know the right terms, although he did use spatter correctly, and he now, at the behest of the prosecution, who was blowing up a table, says that's blood spatter. What do you think? And I'm asking you for a reason.
I'm not convinced because, first of all, he doesn't really support his conclusion
Good
with
answer.
a whole
I don't need
lot.
any more. My witness can go. No, go ahead.
Yeah, he doesn't support it with a whole lot. And, looking at it here, I'm not going to pretend to know as much about this as you do, but I will say that as a human being who has bled before, it doesn't exactly look like blood to me that has been laying out there for days or weeks.
Very good. And now, the education is why, because blood does not stay red, okay? It turns brown, and that's why you can use luminol, ladies and gentlemen, because it works with the iron in the blood. I just cross-examine on this stuff. I'm not an expert. I just know how to cross-examine. I know just a little bit of knowledge about this. And that's the knowledge we're trying to import. But I think that when you cross-examine a police officer, and a police officer can't be the scientific expert. I want to convict the guilty. Okay? But you know what's going to happen again?
Got to take another break.
Another little break. Good afternoon. I'm Linda Kenny Bodden. As you know, we're covering the McStay murder trial, where this tragic case with this family of four, two little, just beautiful children, 4 and 3, found dead, skeletonized in the Mojave Desert along with their mom and their dad. Discussing this case with me is senior legal editor for Law and Crime, Ronn Blitzer. Nice to have you here. Now, we've been making a little bit of light of the testimony because we want to show, I think we want to show that there's so much here that could end up in a reversal, but we're not making light of any of these homicides. It's terrible, just terrible. But one of the things I did want to tell you, do you know from watching this trial whether this table was ever tested?
Personally, I don't know. I haven't followed some of the earlier days in the trial, so I don't think it was ever tested.
Yeah, you're right. You're such a great witness. I wasn't tested as far as we could see from this. And one of the things about science is that you have to test. You have all these tests to test for blood and then so-called experts to see whether it could be spatter. And you know what got me about this apartment is that it was white. There was like white rugs, white floors, white cabinets, a lot of white walls, and it would seem to me that if there was this bludgeoning of 4 people, I would expect to find blood somewhere in that apartment.
Yeah, and
on the white.
Exactly, and you know we're looking at the table with all the splatter, but where was it?
Spatter.
With all the spatter. Sorry, slip of the tongue. But where was it around it?
Good point. Live recourse. Let's see if we know any more. McStay murder trial. We are covering it from beginning to end. I'm here with Ronn Blitzer, senior legal editor. We've been watching as Detective Dugal finished his redirect, recross. We're waiting for a new witness. But a couple of questions have come up. Some want to know whose light that was on the table. We don't know, right?
No, we don't know for sure.
And it was just so everyone understands, that's a battery-operated black light that you can buy in the store if you want to look at your plants too. And you load it by batteries. It's batteries. Whoever puts the batteries in, good idea that the DNA, if it were tested, would show whose light it could be. But the implication, Ron, is that, well, somebody came back to look for a blood spatter, which that light does not do. There wasn't semen because there was no rape alleged here at this house, and some other stuff that could be seen, okay? But why would a person do that if it can't test for blood? Why would it use a black light?
It's a really good question. You know, there are a number of things.
I'm going to trade cross-example. I try to do that.
Yeah, there are a number of things that have come up that, you know, we could look to, or, you know, that jurors might be able to think about. You know, we were talking about just now hearing Detective Dugal talking about the investigator who was brought in to look into things. So, you know, maybe it was his, or maybe, you know, whoever did this, you know, had something to try and cover tracks.
He said it wasn't his. Now
he said it wasn't his.
And it's a UV light that you can buy in the store.
Exactly.
Right?
So, you know, it's hard to say, but you know, I don't know for sure.
That's part of the problem with this. And the other thing that bothered me a little bit is Patrick McStay, the dad of Michael. You know, the dad. I mean, he's the grieving dad. He's got 2 grandkids who are missing, and his son. Apparently, I gathered from the cross and the redirect, there was animosity because Patrick hired a private investigator who the police didn't think very much of. That clearly came through to me, and then it came to the jury. I mean, they're the victims. Does the state hurt its case, even though it hasn't finished its case and we don't know the strength of it? Does the state hurt its case when it looks to be attacking a grandparent, a father? Does the jury ignore that?
I think the jury ignores it in this particular case.
Why?
Because I didn't find it to be attacking the family so much as just this particular investigator. And I think that, you know, you have Dugal here, who had just been ripped to shreds during cross-examination. And, you know,
not by the cadaver dogs, which we didn't let go in the house to examine whether there had been any dead body.
No, I didn't say it wasn't rightly so, but he was ripped apart on the stand during cross, and you know he was made to look at like someone who doesn't really know how to do his job. So here he is saying, "Oh well, no, I know how to do my job. It's this guy who was messing things up."
Oh boy, that could be. That was I just found it a little, you know, just that there was obviously some animosity. The other thing I wanted to talk to you about was this whole idea. That indeed the house was not a crime scene. Therefore, they moved things around. Remember, pictures were taken. Some of the clothes that were in the bathroom had been moved around. If you don't know whether it is or it's not, should you document that house from top to bottom? Or do you just say, hey, most of my cases are, you know, missing people?
I would document everything. If you're going to move something, if you think that this is a missing persons case and they weren't looking at this originally as a homicide, you don't know for sure. You need to at least leave open the possibility that you're wrong on this, or that there could have been something else going on.
I'm having you be my witness.
And you want to look for as many clues as possible. Even if this had been a missing persons case, you want to look at every little thing. But if it could have been a crime scene, and which it was, which they should have thought was a possibility, then okay, if you want to move things around, document it and keep a record, a meticulous record of everything that's going on here. And the fact that that wasn't done
Ronn Blitzer,
really blows my mind.
It blows your mind because you can be my witness, you can be my police officer, you can be my investigator, and you can be my training officer. Because I think the jury's thinking what you're thinking, but we won't know. But anyhow, we're going to listen to more because there was something else that happened with Detective Dugal. He talked about voicemails. I wasn't able to watch today, so I'm excited to watch. Let's listen. Okay, so they're talking about the voicemail, right? Mm-hmm. And they're saying that this defendant, right, didn't have voicemails.
Yeah.
Do you understand why that's important? After the crime scene is not collected, do you understand why that could be very important? No, okay, so you're my juror. You don't, okay? So let's talk about that. If somebody has voicemails and they're deleted, all right, now you have to think back 2010, okay? Old phone, 2000. We've gone a different way. But the same principle applied. Things get deleted by somebody personally deleting a phone, right?
Yeah.
Right? So they have to have the phone in their hand, okay?
You can get fingerprints off of it.
Oh, my gosh. Oh, I just did that. All right. Or you can go to the company, right? And ask when the company records, which they only keep for a very short period of time, by the way. You know, short, but certainly within 16 days, if there were voicemails and they're deleted. Do you know from watching so far the opening statement, if you're sitting there as a jury, do you know which one it is?
Not necessarily.
Not necessarily. Okay. That's not good for reasonable doubt. At least in my opinion, that's not good for reasonable doubt. But I want to go back real quickly to one other thing you said before. I thought it was telling. You said that the table, and this, we're going way back to blood spatter, but remember, it's the totality of the case. The table, to you, was important because blood spatter, when something happens, just doesn't end at a round table. It goes on floors, which are white, rugs, which are white and all. Do you think the jury's thinking like you are? And why are you thinking like that, Ron? What is going through your mind watching Dugal and listening to the lack of evidence here? What's going through your mind?
I'm trying to put together an image of what actually happened because I'm not getting it from this testimony. So when you have the detective who is not really giving me all the information that I'm asking, or as someone who's just watching this, then I'm trying to imagine, okay, well, what happened here? You had a table that's covered in these red spots. Maybe it was blood, maybe it wasn't, but it's being called a blood spatter. And where else is it? If it's a spatter, it shouldn't be located centrally on that one area. It should have been all around. If it's at the edge of the table, it should be on the floor too.
See, so jurors are thinking like you because we read about this stuff, we watch this stuff. So whenever you try a case, you have to be concerned about that. But you know what? We've got to give my expert witness here a little bit of a break. So that means we're going to go to a break. So, Ronn Blitzer, we're watching this witness who is doing her job. She's a crime scene. She's a forensic evidence technician. She's accompanied by criminalists. That's people that collect and test things that when they think there's crimes. She has a detective there. These are all people that are called in when they think there's something bad happening, a kidnapping of a family, a murder of a family, a running away from somebody who may be threatening the family. Why did they just only take pictures?
It's beyond me. We heard from Detective Dugal before that at first they weren't treating this as a crime scene, that they, were just looking at it as a missing persons case. But what is a missing persons case when an entire family is missing? It's not like there's one child who wandered off or a teen who ran away from home and there was no crime committed. When an entire family just vanishes out of thin air, something bad happened.
You see, Ron is getting angry here because he knows that this is not right. He knows that we want to help victims, right? And the grandfather, the kids, my God. But the other thing I noticed here with this forensic evidence technician, she took a lot of photographs. There's no rulers and there's no what's called a grayscale, so you can see the colors. Things weren't taken apart after they were photographed and documented. Now, one of the basic rules of crime scenes, and it's from a French person from hundreds of years back, is that the criminal who comes into a place always leaves something. That's why you have forensic evidence. And always takes something away. Here to the family, for instance, if indeed the prosecution theory is correct. So if they don't collect anything, how are they going to ever find who did this really?
It's a very good question.
I want you to answer because you've been so great on doing this. What does the prosecution do?
What does the prosecution do? They're going to look to whatever little bits they do have. They're going to go with the information that the police actually did get, which here wasn't a whole lot compared to what we think that they should have done, but you go with what you have.
Okay, so can we listen to her a little more? Let's see if we're going through these. I think it was someone said 745 pictures. Anyway, there was a lot of photographs taken. Let's see if any of them, if my criminalist here can see somebody. Oh, actually, you know what we have to do again, Ron? I'm sorry, Ron. We have to go to break. Break. Okay, so we have on the stand, and I think she's going to be there a little bit longer, maybe just a little bit longer, Dennis Williams. She is the forensic evidence technician, now retired, who went to the McStay family scene with the criminalist, with the detective, to take evidence that may be important and document which may be important, which she's trying to tell the jury. Now, Ron, okay, she used, and us trial attorneys, the same word. I was horrified when I saw that picture of the table blown up and those spots. That horrified word is the same word that Dugal used, and yet supposedly they saw this at two different spots. Does the jury pick up like I do, or is it just because I do this stuff for a living on the use of the same word?
I don't think the jury's going to pick up on that. What I hope they picked up on, though, is when she said that she's not a trained expert in this sort of thing. We were both practically jumping out of our seats during this testimony just now because she's asked her opinion at the time of what she thought this could have been, which you're not allowed to do. The attorney might have just flat out used the word speculation and say, "Oh, can you speculate for us what this could have been?" And we're both yelling objection here in the studio. But on top of that, we're not in a courtroom. We're just going up and objecting, right? And then after that, she's saying, "Oh, I'm not trained in this." Well, then this is irrelevant. You can't lay a foundation for any kind of expertise here. She's saying the opposite, saying, take whatever I say with a grain of salt. So I'm hoping that's what the jury does. If they hear her saying that she's not trained in this, so anything that she says after that isn't all that important.
Yeah, what happens, in my opinion, is that they all begin to be a team to convict who's on trial. Now, again, we haven't heard the evidence. We don't know whether Mr. Merritt is guilty or not guilty and going to be convicted. But when you have a 3-year-old and a 4-year-old and a father and a mother, and then you have living grandparents who are just dying. I mean, they're literally dying inside, right? I mean, they're owed a duty to have the best evidence and be convicted on the best evidence, or else what happens?
Or else the guilty party goes free.
And maybe the wrong party gets convicted.
And the wrong person can be convicted. Either way.
Or the right person's convicted on shoddy evidence, and other prosecutors do it the same way.
Exactly.
Which is what there is at this National Academy of Sciences report. We're trying to make science in the courtroom real forensic science, and the reason we try to do it, Ron, is that we do owe a duty to victims. I'm a defense attorney. We do owe that duty. We want to convict the guilty. We want to let the innocent go free. Ron, it's been so great having you. You're my everything today. Law&Crime Network, stay tuned. We'll be back on this case tomorrow. Bye-bye. See you next week.